And good morning, everybody. This is Vinny Miletti with Miletti Law, the strongest name in law. The date now is January 16th, 2022. It is a wet and rainy Sunday morning here in Savannah, Georgia. Over here at the First of Many from Miletti Estates. Leaving today to go to Florida, but we'll come back here shortly, momentarily, to hang out and finish developing this place. First and foremost, before we continue ahead, please make sure to click the subscription button below in the YouTube channel, and make sure to go to the website www.milettilaw.com, www.milettilaw.com, and go ahead and sign up for the newsletter so you can always be in the know and up to speed with all the exciting information we got going on and new fresh content always coming out and all our marketing and media stuff. All right, so it's another one of these Miletti Law training videos here. All right, so as a backdrop, by now, if you follow these videos, you will know what a non-compete is. You will know what restrictive covenants are. These are contracts that employers have employees sign and execute in order to, protect their confidential information and to kind of protect their interest. Employers, spend a lot of money in developing employees and, want to ensure that all that information, all that training material and guidance that they give them, was actually valuable and worth it. Sorry, it never fails. Here he comes. Here he comes. I don't know if you could see him. No, you can't. He's not big enough yet, but here's the it never fails, this dog. Anywho, so basically today we're talking about non-competes, we're talking about restrictive covenants. Keep in mind they are state by state, right? So there's no general law around the entire country for non-competes. They are treated differently in every state, depending on where the employer is located, depending on the work is located. Generally, your employment contract will discuss which state or which venue or jurisdiction of law is applicable. So, that's the first part. But one thing I do want to point out today is, so we had a situation where an NDA was, handled a little bit differently. Non-compete is handled a little bit differently. In California, non-competes are, I think they're restricted in California. They're prohibited. I think Colorado also joined that. In New York, they're strongly discouraged, though New York does recognize a need for them. They are discouraged in New York. But this one came up in Florida. Now, Florida is very employer-friendly. Anyone who knows or has business in Florida knows Florida is very pro-employer, very lax when it comes to protections for employees. There's like a very minimal threshold for that. So it's going to be treated very differently here in California, NDAs and non-competes. They're going to be treated differently here. They're going to be treated more in favor of the employer, and the restrictions on the employee are going to be stronger and upheld. So generally speaking, all right, let's plan this. All right, so what's the law in Florida, right? Florida actually has a statute that governs restrictive covenants. That's known as the Florida Statute 542.335. This also governs enforceability of that. The way restrictive covenants are defined in that code is just simply things that restrict the employee from behaving in a certain way upon either during or at the separation of employment. And, it's always for like a limited amount of time. In order for a restrictive covenant in Florida to be enforceable, so what that means is in order for the employer to be able to say, hey, you signed on that contract, you cannot do this, this is a bad act, and you're prohibited. In order to be enforceable, a couple of things need to be there. Three main key elements are: one, it needs to be set forth in a writing, signed by the employee, right? So the employee has to get a writing of it, signed by the employee. Element number two is the restriction must be reasonable in time, area, and in the line of business. So generally, like any other state, it has to be reasonable in the duration, it has to be reasonable in the geographic scope, and it has to be reasonable in the industry. It has to be limited to the particular industry that the trade secrets are in. And then the third element is that it has to be supported by a legitimate business interest, one that's reasonably necessary to protect that legitimate business interest. So we've made this example before in the past. I'll make it again because I always think it's very funny. You're a janitor. You have a special way how to wipe toilet seats. Might be fine and dandy. The company may give you a special way to wipe toilet seats. That's not confidential information. You're not advancing a legitimate business interest generally for a corporate office if you have a fancy way how to wipe toilet seats. So keep that in mind. So those are also codified and found in section 542.335.1 B, C. That's Florida statute section 542.335, subsection 1 A, B, C. Those three in there. All right. So the statute also provides a couple of extra things, right? So it gives you a list of legitimate business interests. It gives you what are presumptively reasonable and unreasonable time restrictions, some which are rebuttable, some which aren't. And then where the burden of proof lies in Florida. The burden of proof is on the employee or the employer. Keep in mind that as to the first point of that, the legitimate business interest, it's been clear by the courts in Florida that this is a non-exhaustive statement, that it really could be anything that is a legitimate business interest based on the common definition of a legitimate business interest. So remember, the whole point is that Florida law is more favorable toward employers, and at the end of the day, that's what you got to keep in mind, right? So if your employer has a non-compete in place and they feel like enforcing it, odds are they're going to be in a very good position. So, don't discount that. It's not like New York. It's not like Florida. It's not like Colorado. It's Florida. Employers are generally favored here, and that's something you're going to have to learn to deal with while you're functioning down here. So also the courts also, by the rules, have certain restrictions on what they can consider in whether or not a restrictive covenant is enforceable. So, and these are interesting because this is purely unique to Florida, purely unique to Florida. So courts are not permitted to consider the individual economic or any kind of other hardship that might be caused by the person against who enforcement is sought. So, in other words, if I sign that contract to work for this company and, I'm saying that by enforcing this, it's going to cause me substantial economic hardship, courts are actually not permitted to review that in the analysis, which is interesting. So that's very unusual. That's very unique to Florida. Courts are permitted in Florida to consider defense that the person who wants enforcement is no longer in the area of business. So let's say, I work for an insurance company and then the insurance company went out of business. They can't seek to enforce that non-compete or that restrictive covenant if they're no longer in business, because it doesn't make sense. A court must consider any kind of other legal and equitable defenses. Thus, this is an issue of equity, though, remember, the courts are supposed to take a firm stance and they're very pro-employer. And a big thing is the courts are required to consider the effect of enforcement on the public health and safety and welfare. COVID's a great example of this. If you are someone who signed the restrictive covenant, let's say, and, you were providing services just curing COVID, whatever the case is, I doubt any court would uphold a situation in which, you're not permitted to do what you got to do to ensure that those who suffer from COVID would be corrected and healed. So, that's another area there. That's particularly important during this day and age, the effect upon public health by enforcing this restrictive covenant. All right. Let me just go down the list here. Same thing with just specific non-competes. There are restrictive covenants which restrict certain rights and things you could do. And then there are these things called non-competes, which are just specifically you can't compete with people. Keep in mind there are a bunch of restrictive covenants, a bunch of different types. And he stole my slipper. There are a bunch of different types of restrictive covenants. I tried to get the slipper back while I was talking to you, but it was just not going to happen. And I was chewing it. Anywho. All right, so there's a bunch of restrictive covenants, right? So you have a non-compete, a non-solicit, a non-circumvent. Non-solicit means you're not pulling the employees away or you're not pulling the clients away. Non-circumvent means you're not attempting to do an end run around the contract to get what you want. Non-compete is obviously not compete against the employer. Before we just talk about restrictive covenants in general, specific enforceability non-compete could be found in, same three elements, right? Set forth in a writing, reasonable in time, area, and light of business, and supported by legitimate business interest. There are a couple of items that are just straight up able to be protected, and a court will enforce the restrictive covenant, the non-compete. Instances in which trade secrets are clearly defined, instances in which real valuable and confidential business information that otherwise would not have been disclosed but for your position will be affected. I don't know, let's say you have unbelievable records and databases of a company you worked for, that's considered confidential information. really substantial relationships, let's say like government contracts, right? You can't take those. They're going to be protected. Extraordinary specialized training. I don't know, let's say the training that they invested in you as an employee was a $400 million training where you learned how to build semiconductors from scratch. That's important. So that's going to be upheld. That's going to be a legitimate business interest. And then also, the most obvious one, which is in everybody's face, is going to be the customer list. Like that's legitimately a legitimate business interest. So most people, when they walk away, that's what they want to take with them because they build that customer list. But that is like the traditional confidential information that you always see in these situations. Reasonable time restrictions. Florida is a little broader. Florida will permit a longer time. For most of the country, I'm always saying that if you're in a state that does enforce this, like 1 year is generally reasonable. I've seen Florida go up to 3, 3 and 4, sometimes 5 years. So, let's just say it's a reasonable time frame. In Florida, 2 years seems reasonable. Reasonable geographic scope, basically the area which is covered under the non-compete. Florida's wild. I've seen from 10 miles, as low as a 10-mile radius to the home office, to 150-mile radius to the home office, which is a lot. So, that's big. The geographic scope. And that's it really. And then I think I already went through it already, but the legitimate business interest, there are many defined, but even if they're not defined, it's not exhaustive, and the court can rule and depend on it. So they have it in a nutshell. So just to wrap this all up in a very easy, concise way that you went through this entire video. Restrictive covenants in Florida are generally upheld. Restrictive covenants include non-competes, non-disclosures, non-circumvent, and non-competition. I said non-compete, non-circumvent, and non-solicit. So non-compete, non-disclose, non-solicit, non-circumvent. These will be upheld in Florida. They are very strong down here when it comes to employer rights. And the big 3 elements have to be met. It has to be in writing, it has to be signed by the person that you want to enforce it on, the employee. It has to be reasonable in time, duration, and scope. And on top of it, has to protect the legitimate business interest. The statute does provide us with legitimate business interest and a list of them, and that's not exhaustive, and courts can fashion it as they like. And that's it here from Milady Law. So if you do have an NDA and you have one in Florida, be very careful where you tread. Florida is a little bit stricter. And, if you have any questions, obviously we're here to help you. Feel free to reach us at the website. Feel free to reach us, at a phone number, on Google, and Skype, on Yelp, on, Avo, Facebook, Instagram. We're all over the place. So reach out to us. Let us know if you have any questions or concerns. If you have anything else you need to know. And obviously, always wish you all a wonderful, wonderful, wonderful day. All of you, yours in law, love, and lifts. This is Vinny Milady, the founder, owner, principal, godfather, God King of Milady Law. And I will see you down the road. Have a great day.